Do I gotta have it? I ain't even playing, got a really bad habit. If it moves, gotta grab it. Fuse like a magnet, lose, won't have it till I'm doomed in a casket. I ain't playing, got a weird mind. If you work 8 hours, I'ma work 9. If the shit tastes sour, you should taste mine. I'ma stay in power for a long time. Get up, nah, I ain't a quitter. Toss me the ball, I'm a really big hitter. Big picture, I'm a straight killer. Rising the song to the highest bidder. Got juice, got gas, I'ma move fast. New shoes, new tracks, like who's that? I'm new, come back, better than last. Yeah, it's a new me, never gonna look back. Never gonna look back. Cause damn, I was built to last. You move slow and I move fast, and that's facts. Only I can make a change. Slowly take a step today. I will never be the same, cause that's what it takes.
Woo! Let's go. Happy Thursday, everybody. We got Cowboy and the Corax here. Corax, can you hear me? Let's do a mic check for you.
Yippers.
All right.
I can hear you. I need to get a kick-ass intro like you have.
I think I got that off of YouTube Studio. Some free song, you know.
Nice.
All right. I'm going to give folks a couple minutes to get in here. We got a lot of document drops today, huh, Corax?
Yeah. A lot of ownage coming down from Vice Chancellor Zern, too.
Let's go ahead and give you a moment while folks are shuffling into the room to give a shout out to your channel and tell them who you are, just in case it's their first time here.
Sure thing. I am a Noisy Corax, also Sonny Corax on Twitter, though I do have the Noisy Corax header on there, so it's easier to find. I do videos really about, mostly it seems like the topics people are wanting to listen to are sort of the ins and outs of the legal stuff that's been going around with AMC, though I also do stock related videos and research stuff. Just got done dropping a video on NCMI.
I watched that. That was a good one.
So I'm not sure exactly what I'm doing coming up, but I'm much like my namesake. I see a shiny object and I pick it up and I make a video about it. So
I appreciate the work that you're doing on NCMI, because that saves me literally days of having to go understand what the heck's going on.
Yeah, and it helps that I have a Pacer account, so I can follow the bankruptcy as it goes along. It's infinitely cheaper than following any of these Delaware cases.
Yes, ridiculous. Mods, just a heads up, full troll blocking tonight. No mercy, just mute them, and I'll take care of kicking. I don't want any accidental people like Scavenger Kick. So he was being sarcastic last night, and was it last night or whenever I was last on, and the mods didn't know. So just mute them, no mercy, and I'll take a look at the comment and kick them. With that being said, for those of you that are willing to learn, you know, there's no wrong comments on this channel. We don't want to stop anybody from having your thoughts heard. But if you're trolling, like saying bullshit over and over, or if you're being rude to people in the chat or one of the hosts, that's an automatic block and never come back. Corax, let's look first at the postcard affidavit. Did you get a chance to look at that one?
I have not. I saw that you posted it.
All right. I see the mods already blocked someone.
Oh no.
All right, he's gone.
Let me make this full screen so I can read
it.
Yeah,
if your only comment is insulting somebody, then you have no intelligence and you're gonna be instantly muted. The mods are on top of it tonight. So don't waste your time. You can create as many alt accounts as you want. They are going to be on top of it. All right, here is the affidavit that was due by June 22nd that goes over how many postcards were sent and what was causing all of the delays, or at least some of them. Brian Hunn, thank you, sir. Yeah, we got 90 pages to go through. We're not going to be here all night. I can promise you that. We're going to skip through. If you guys haven't heard, I do have a speed reading ability. Wink, wink. How did he read 1,700 pages, Corax, in one day?
I skipped over the fluff stuff and went straight to the.
You guys want to know how I read 1,700 pages the first day they came out on May 20th? I'll give you the secret. I read the filings for the last 2 years, and the majority of everything in that 1,700 pages was surprise AMC SEC filings. So I already know what I can skip over. The really important stuff was the board meeting minutes, the emails, and things like that. So I feel sorry for all these people that are protesting that have never once in the last 2 years read a financial statement or any AMC filing. They're just like, I need 5 hours per day, judge, to learn all this shit. Buddy, you had 2 years. We've been putting in the work, so it was very easy for me to read that.
And if you were really this interested in this lawsuit, why weren't you up to speed on this and filing with the rest of them?
Yeah, so we're going to spare you hours and hours of listening to 90 pages. We're going to touch on the important stuff, and mostly it's going to be to provide you now court evidence from the plaintiff, Allegheny, and from the defendant, AMC, and we'll probably go into some of the special master and Zern's motions, reiterating in their own words exactly what we've been telling you was going to happen legally for the last couple months. And now, these are not my opinions, guys. What I think about the lawsuit, or what Corax thinks, or what you think, whether you're a yes or no voter, does not matter. I've been sitting here trying to read you the filings and tell you how the court was going to look at all of these objections and stuff. And today we're getting a lot of those answers, and it's pretty much exactly what we've been telling you. Would you say that's a fair summary, Corax?
I can tell you, having looked at how the plaintiffs and the defendants responded and all the stuff that I've seen, not a single word of it has surprised me.
All right, so we got, let me see if I can move us off to the bottom there. This is from Paul Mulholland. He is the president of Strategic Claims, and they were the ones that were contracted out to send out all the postcards. They're a nationally recognized class action administration firm. Just in case you didn't know, AMC did not send out postcards. Your brokers did not send them out, except for maybe a couple of exceptions that requested to send them. This company was in charge of sending the postcards. And this is his affidavit to the court that he tied with the judge's order. And it goes through all the numbers, everyone he contacted, and the problems that they ran into. So let's just skip down to number 4, where he starts talking about what happened. He contacted 16,382 people directly. Letters went out on May 1st, people that were registered with ComputerShare. Actually, were provided to SCS by Wheel, Gottschall, and Manges LLP. So they probably...
That's AMC's lawyers, I think.
You're right. This is the individuals and entities that owned common stock for their own account, which is DRS, or the accounts of their clients, which would be the brokers. And then he goes on to say, the most of the people, are beneficial owners. Most people are not DRS, but DRS people, their letters, their postcards went out on May 1st. Strategic Claims maintains a list of 851 banks and brokerages, as well as 1,500 mutual funds, which we don't care about those. And they sent them all a letter on May 3rd, notifying them that within 5 business days, they wanted a list of all beneficial owners. That'd be like the normal people like you and me. Send us the names and addresses. On May 8th, they also sent a postcard to the DTC to publish on their legal notice system. And within 5 days, 5 business days of receiving a receipt, SCS either mailed or emailed postcards. Yes, emailing was allowed to the beneficial holders. And then Exhibit D, which we're going to talk about briefly, we're not going to spend a lot of time on it, has a list of everybody who responded and when they responded. As of May 31st, 2.8 million postcards or were mailed or emailed. And we'll talk about why. Where's the other million? We'll talk about that in a second. Throughout the process, SCS called and sent reminders over and over to these people to get them off their ass and get the lists. And they were dragging ass, the brokers. 45 follow-up calls and emails asking them to send in their damn list. Now, I know a lot of people want to blame AMC, blame anybody except trying to, like I was telling you to, take a breather, try and understand the process of what's going on here. Now, when we go down to Schedule D, this is their list of everybody they have. Schedule D is I posted this on my community tab and on Twitter, so you can look at it at your leisure. This shows basically all of the brokers, Corax.
And most of the main brokerages, the big ones, are all under Broadridge.
Broadridge, right. Fidelity, if you're asked, a lot of people are asking where's Fidelity. That's National Financial Service. It shows how many names and addresses they sent back, what date. So Fidelity responded. Remember I was telling you they had 5 business days, so they should have responded by about the 7th, I think it was. They didn't even respond till the 17th. Because we thought all the postcards were going to be postmarked by the 17th. But this big-ass broker with 1.2 million names didn't even respond till the 17th.
Could not be bothered.
Yeah, and SCS mailed them out the next day, 5/18. Robinhood down here didn't respond with almost 6 million names till the 22nd of May. And they got those out by May 26th. So if you're wondering what was causing all the delays, this is some of the problem, just the friction in the system.
And that's like just what I think we had both said, that it's the chain of custody when you have people acting on your behalf like a broker, where if you had it DRS'd or you had something sort of like that, it just goes straight to you. But when you have to wait on the broker, and then the broker has to get the letter to your address, and then UPS has to snail mail it.
As far as any certain broker that you're asking about, like where's Webull, where's Ally, I don't know. We're going to need to study this list. I don't know if Webull is like one of the 43 under Apex. I only just looked at this not even an hour ago, and then I had to get ready for the live stream. So it's out there for you to look at on my Twitter and my community tab. And feel free to comment. So that's that. The affidavit is in, the explanation of what happened is in, and you have all the data that we have right now. Let's look at what else interesting happened today. Plaintiff. Let's look at this one. Have you read through the plaintiffs? Oh, wait, I want to look at the defendants' response.
I've looked at both defendants and plaintiffs because I have the wonderful trick of being a delivery driver where I can set it to PDF read to me while I'm driving down the road.
Oh, nice. Let's look at the plaintiff first, because I think the meat of it, I don't want to focus on what did AMC say, because people are just going to tear that apart.
Yeah.
Let's look at what Allegheny said. But there was a couple of interesting things in here. Right here.
I was unsurprised by page 16, but you get to it wherever you want to drop on it.
Most of this, we're not going to spend a lot of time on. Like I said, it's almost all, would you say, in my opinion, most of it was repeated in the plaintiffs.
Both the plaintiffs and defendants were pretty similar. There were some different things the plaintiffs went over because they had to deal with since their representation, they have to fend off claims that they weren't represented properly and fees and all that stuff.
Yeah, and I'll put the links to both of these in the video description when you're done, so you can see we're not trying to hide anything. You guys can go read it at your leisure. Just in the interest of time, I don't want to read one document when I know that the other one has all the same info. So I'm going to focus on what was different in AMC. I don't want the plaintiffs, I want the defendants. Defendants reply. Here we go. You said page 16.
Oh, I was talking about the plaintiffs ones.
Oh, yeah.
You're looking at the defendants.
Let's do the defendants first.
Anything that pops out to me, I'm just quickly scanning back over. I mean, 11 was pretty obvious to all of us. The defendants need to raise capital, and
yeah, I mean, we beat that horse to death. We'll go through on the plaintiffs exactly what they said about that.
Trying to see if there's anything super interesting. Oh, hey, this one's an important one. Page 24, proposed settlement should be approved as a non-opt-out settlement. This is the big sticking point with a lot of these objectors, that they should have opt-out. And I've said loudly that's not going to happen. But
I don't know that we need to worry about that. The judge is going to decide.
Mm-hmm. Yeah.
I mean, it doesn't really matter to me.
That's fine.
But I mean, obviously both the plaintiff and the defendant are saying they want it non-opt-out.
Because the claims are the same. There's no divergence of claims between all of the members of the class. They're like, Tony, you were affected just as any other AMC shareholder. It's not like AMC came over with Adam Aaron and they burned your house down. You know, the claims are all similar.
I feel like if we focus on that right out of the gate, it's going to get people upset, because some people feel a certain way about that. I don't really care. And it doesn't matter what I think, because the judge is going to decide on June 29th and 30th. AMC says that the objections talking about receiving a postcard are meritless.
Yeah.
There were several letters from the court today and from the plaintiffs and defendants saying, if you contacted us to let us know you didn't get your postcard,
guess what?
You are in essence saying that you knew about the lawsuit. Now, I've been talking about that for almost a week and got called all sorts of names. Like one guy said, are you smoking crack? Like, why would you think that? Because I use logic.
And they were making also the argument that, well, we're doing it on behalf of other people because all these letters hadn't gone through and everything. And another thing that I'm sure is pointed out in both of these is that, well, the onus is on you. If you have a broker third party that you take that risk.
Not only that, but one of the objectors you pointed out to me got warned by the court today. If you're trying to argue arguments on behalf of other class members, you could be charged by the court for illegally acting as an attorney.
Yep.
So you have to, I mean, if we ever go through this again, you got to focus your letter and your objections about you, not the other people, because the court doesn't care about that. And
the only people that you can care about in these situations is you, unless you're a licensed attorney who has pro hoc viced their way into the court representing someone.
They say that SCS went above and beyond the requirements. We just looked at that letter. In any event, under well-settled Delaware law, beneficial holders assume the risk that they may not receive the notice from their nominee or custodian. That is the first real benefit of DRS that I've seen.
Yep.
Corax?
Like it's a give and take. You're a lot less liquid, but since you're the direct custody holder, you're protected in these situations.
Yeah, they were the very first ones, people that DRS that got their postcard. So let it never be said that the cowboy never said one good thing about DRS. Log it right now. I can't wait to watch the videos. All right. What else we got here? Attacks on the release provided to defendants under the settlement lack merit. This is just objections that ask to opt out or the opt out of the settlement are inappropriate. Like, I don't know. You could object, I think, if that's your right, but why would you also opt out, Corax? Like,
opt out, they basically what they're trying to do is they want to continue the lawsuit. That's the reason why they want to opt out, but that means they opt out of the settlement.
Thousands of people have signed a opt-out petition. Do you think that thousands of people have the means monetarily to go sue AMC in Delaware court?
No.
I mean, what's it costing Allegheny? 20 million?
Probably nothing, because at the end of the day,
but you know what I mean. If you lose,
right,
it's not cheap to go fight a case,
and it would be expensive. The other thing is that the current plaintiffs have the benefit that their costs are probably going to be defrayed by AMC's insurance paying for them. Whereas if you opt out and continue the lawsuit, AMC's insurance company ain't coming to pay your bill.
Yeah, when I say what's it going to cost Allegheny, I mean, obviously I know AMC's paying their attorney bills, but I just am like putting in scope what kind of attorney bills can you run up fighting a case like this?
Well, considering that they were charging, like, let's just take Special Master Amato's bills into consideration. Her normal fee is $600 an hour. Now think about all the man hours and everything that went into that case, and then times it by 600.
All right, so it's a minor point, but if you opt out, you also don't get the settlement. Mm-hmm. So don't opt out if you're not planning on suing, I guess would be
and being
my
able
thought.
to afford it.
Yeah, if you can afford to sue and you want to opt out and you're able to at the end of the day, because the judge allows it, then hey, knock yourself out. I don't care. But if you're opting out because somebody on YouTube said opt out, they're screwing you out of your settlement.
And personally, if you want to do this smart, like say you believe the conspiracy theories like Al from Boston, whatever, take the settlement, because none of those claims are being addressed here and you can still bring them.
Oh yeah. All the other things there. Yeah. Like the synthetics and the share count. Yeah. None of those are going to be addressed in this case. You can always file a separate case for that. That's true.
Have your cake and eat it too.
I wanted to, there was one paragraph in here that I wanted to talk about, and then we'll go into the meat of it in the plaintiffs. Rose Izzo, Blasius.
While you're searching there, I'm just going to address Blake. The problem, Blake, with them being sued in criminal court is that none of what they've done is criminal. It's all civil. So they can't be brought in criminal court.
I see a lot of people saying, well, never mind. Doesn't matter. This is a civil case. No one's going to jail from Judge Zern. Let's put it that way. Now, could a criminal case be filed? That's possible if someone wanted to. Talk about the money. We're going to get to that in the plaintiffs. Money. Postcards. Izzo. Get down, cat. Yeah, feel free to grab any questions while I'm searching for the one paragraph that I was looking for in this document.
Yeah, I know most of the stuff that I was interested in is on the plaintiff side, because like you said earlier, like, what defendants said is mostly going to be ignored by most of these people. And what they said is, I'm not surprised by anything.
I don't even see it now. I'm going to put it up on the other screen so we can talk about the plaintiff, and I'll find what I wanted to talk about, and we'll come back to it.
What I wanted to on the plaintiff side, because there was a couple things in there that I remember when I was listening to it at work, but it's hours later, and hopefully I'll be able to find it.
All right, this is from Allegheny, and let's just kind of understand the process right now. When you're in a class action and the plaintiff and the defendant have agreed on a settlement, as Chance the lawyer told us, they are basically both working together to get the settlement passed, right? Anybody that's objecting is an antagonist to this team effort to get the settlement passed. So if you feel like the plaintiff is working against you, if you're objecting, you're probably right. Is that a fair summary, Corax? Am I misstating it?
Yeah, they consider objectors as opposing parties.
Yeah. So I see people getting mad, what the plaintiff is saying. Their objective here, they've looked at all the discovery, AMC's books, all the board meeting minutes, thousands of hours, and they've put a lot of work into what they think is a fair and reasonable settlement. So they would like to see that get done, for or worse. I'm not making judgment. I'm just trying to help you understand what is going on. You don't have to like it. I get it. Some people are very upset by it.
I don't know what you have of interest in there, but I know mine's on 18. The first one is.
The first few pages are just a recap. We got here. This is talking about objectors being angry against AMC and the fiduciary duty. Allegheny plaintiffs recognize many people have suffered life-altering losses if they bought at a high price and are still holding. But many feel passionately that regulators and market actors are colluding against them. Allegheny says, the attorneys say, Allegheny plaintiffs, are we included, I guess, as the class?
Yes, you are technically.
They're saying we're not part of any such conspiracy, neither is the court. And moreover, these issues lie far beyond what is before the court. I don't know how many times I've said to folks in passing and replies and comments, you can object about anything you want, but if it's not something that was brought up in this case, you're just spinning your wheels. Like, this case is not about dark pools, share counts, Gary Gensler,
Ken
Griffin. It's just not about that. That's not my opinion. I understand your frustrations, but we're talking about this court case, and all the past couple months that I've been here reading court documents, that is the focus, not what anyone feels, but helping you understand what you could hit home with if you wanted to object and what was going to just be deflected because it's not part of this case or the court doesn't have jurisdiction over it. So plaintiffs are reminding folks about that. A lot of the objections had nothing to do with this case, and this court is not the proper place to bring them. There is a lot of talk here about the 242B claim. There was one paragraph. I already posted all these in my Discord. I should have highlighted it in here. But the objectors have a different viewpoint on the 242B. We already know that, Mr. Tuttle and his friends. Allegheny said that I think they must answer on the next page.
Yeah, and they mentioned 80-year-old precedent, and they go into that on page 18 where they
18. Okay, I'm making my way there. I just want to make sure I don't skip any of the good stuff.
There's just probably plenty of good stuff in between there, but yeah, they bring up Dickie Clay and a couple other citations.
All right, there's been a lot of misinformation about. People are asking me. I'm getting messages. Tony, is it true 85% of shareholders objected to the lawsuit?
85% of respondents.
80 to 85. Look, there were 3,500 letters sent in. Of those, let me see if I can make this a little bigger. 2,850 objected, which represents I don't know if this math is correct. Did you check it?
I have no way to be able to check it because I assume it's based on the private information they have of people's brokerage.
Well,
statements.
2850 divided by 3.8 million.
Yeah.
I thought it was 0.07%. Not. I think they added 2 zeros accidentally.
Maybe.
You know how we all make that math mistake every now and then?
Sub 1%. That's
it's under. Yeah, it's not even 0.1%. 2850 objection letters. I heard all kinds of wild numbers being passed around in the tens of thousands they were expecting, but 2850 objections,
which make no mistake is unprecedented for
it is unprecedented. Yes, even Chance said if it was a few hundred, that would have been unprecedented. So it is a large number. But when the only reason I'm harping on this for a second is when people say 80% of shareholders objected. No, 80% of the letters that were sent in were objections. That is factual. People are getting listed.
Especially when the court had already said, look, the plaintiffs and defendants are going to be arguing for this, so there's no need for you to send in a letter.
Yeah, I wasn't going to waste my time sending a letter when the judge said, don't bother. You know, if you support, we don't need your letter. Of the 2850 that objected, half did not include any information regarding their holdings. So already half of them got tossed out. And I told you guys this a long time ago, that most of the letters that got sent in were going to get tossed because they didn't follow instructions. So half didn't prove that they owned stock. And then of the ones that remained, they only included some evidence. The vast majority did not comply with requirements.
We told you, the court told you, Tony and I told you, Chance told you,
follow the damn instructions.
And you need to have law supporting it can't be just, I don't like the settlement. You have to give a reason why the court should care that you don't like the settlement.
Nevertheless, they go on to say, they treated any apparent good faith attempt to include proof of ownership as sufficient. So they didn't just toss it like I'm being a little harsh. I get it. They treated any good faith attempt to include proof of ownership as sufficient to constitute an objection. And they categorized them into 11 categories. APE was illegal. They didn't like the stock split. The vote was invalid. AMC colluded with Antara. Naked shorting, dark pools, objections to the fees. I like that one. General fraud, need for additional discovery, collusion with Citigroup, AMC's long-term, long history of being their financial advisor, lack of due process, and AMC's need to raise capital.
I like the disputing fees one too. I brought that up. It's a shame that none of the objectors used my idea. Not that
you liked what?
The objecting to the fees, and I gave a good reason for why you could object to that. It's a shame none of the people that sent in letters listened to it. Because if you go down there, I don't know where it is exactly, but they mentioned that Izzo even brought it up, but she didn't give any factual basis for why their math was wrong and her math was right, other than pure suppositions. But it's so easy to prove that their math is shit.
I think this is an important paragraph here. The objections are mostly predicated on misapprehensions regarding what the case was about, the type of relief available, and the jurisdictional scope of the court. No objector challenged the reasonableness of the give compared to the get. We'll talk about that a little bit further down here, or otherwise provided a valid reason to reject the settlement. Remember, all of your objections had to be, the only thing the court wanted to hear was, why do you object to the settlement? What was your legal basis for objecting?
Based on the facts of the case. And this big paragraph is all about them defending the give and the get of because that's the big thing in the Activision case, that settlements have a give and a get. What are you getting out of the settlement? What are you giving up to get the get? And how are they balanced?
Yeah, actually, this table right here is just starting to get into how little cash AMC was projecting that they were going to have. All right. I want to spend a second on this. Taken together, the discovery record indicated, again, remember, Allegheny went through all of the board meeting minutes, financials, financial analysis, internal from AMC and external. Many different other Wall Street firms were analyzing and trying to make predictions about the stock price and stuff. The discovery record indicated that without APE, if there had been no APE, AMC would have been out of cash in the second quarter. That's right now. I've been talking about the risk of bankruptcy.
Yep.
And I just am pointing this out that, like, for example, if APE was ruled illegal and some people are saying, pay us our APE back. If they raised $480 million in APE between Antara and At the Market, we have $495 million. If they had to pay APE back to everybody, AMC would be left with $15 million. So that's not going to happen. Plaintiffs could not ignore the risk that the court would deem this a compelling justification for recapitalization. And then they quote one of Adam Aaron's emails from January 2023. It was absolutely crucial action to raise money with APE. We can all argue about, did he get the best price for it? Yeah. Not going to argue with you about that. But the point is, we're at where we're at. The discovery. They looked at how much money was raised, and they are admitting and agreeing that without APE, period, AMC would have been out of cash this quarter. And even with APE, only likely have a couple quarters of cash runway.
And even then, if you disagreed with how Adam Aaron structured the deal, as far as with Antara and all that, that still falls under business judgment. I know some people are really mad about how the management of the company has managed things, but at the end of the day, you can be mad at it and it still not be illegal. It is not illegal to make a bad decision.
Yeah, they will. We'll get into that when we get into the 242. Ms. Izzo is going on in her complaint about EBITDA. I don't, you guys already know that follow my channel. I don't really pay much attention to EBITDA because you're deducting a lot of shit from it. Mm-hmm. And you've heard me say that many times when we're going over quarterly earnings on various companies. It's an interesting side note, but you don't base a legal argument around EBITDA.
And I like EBITDA, don't get me wrong, but like you said, it excludes a lot of stuff, and you have to be careful what businesses you use EBITDA on, especially adjusted EBITDA. That's a non-GAAP measure. Anytime I see adjusted anything in some financial statement, I just read it as bullshit. Substitute adjusted for bullshit.
Yep. Exactly. We've had that conversation on my channel many times the last year. After another few quarters burning over 200 million, AMC will have exhausted all liquidity with only the low price, high dilution APEs as capital raise to counterbalance the cash bleed. If we were stuck with only having APE after this is all done. And they go on to say that taking on, one of the other options is like, well, why did they sell APE? Why didn't they just get more debt? Again, we've talked about this, taking on more debt when they already have 5 billion or 10 or 11 billion, if you count all the leases.
And they're still bleeding cash. Where the
company's market cap is 4 billion is not a viable liquidity management plan. That would, you're just inviting more shorts. Take on more debt, you're going to get shorted to death. Objectors also complained. They acknowledged the AMC ended the quarter with 496 million, as we all know, and cash and cash equivalents. And then we have the 208 million credit facility. And they said that seems like plenty of cash. Just pay it back. They even calculate that, except for AMC would have 16 million in cash. That should be plenty, right? Including that 208 million revolver. No. Again, if you're Wall Street and you see a company AMC size that had to pay $480 million back, and that leaves them with 16 million in cash, game over. Shorts will obliterate that company.
Especially when you consider that revolver. People think, oh, well, they've got this revolver with the extra cash funds. That's the backstop for their loan contracts, where they have to have a certain amount of liquidity and cash reserves, otherwise they default.
That's like that $100 that your wife tucks up under the back of the drawer in the bathroom. You ever heard of that trick, Corax?
I've heard of stuff like that.
I've had many rental properties, duplexes, and I would always do a very thorough inspection after people moved out. You'd be surprised the places where you find that people hid money and forgot about it.
I bet. Call it a tip.
Huh?
Call it a tip.
Yeah, that's finders keepers. The only reason the company is not down insolvency this quarter is its highly dilutive APE offerings. So they're saying, yeah, APE was dilutive, but it is the only thing that saved AMC from not filing bankruptcy right now. We're almost to 18, Corax, and then I'm going to let you talk.
Okay.
We're on 16. Are you going to talk about 242?
I could talk about it roughly. I mean, most of that first part is the stuff that we already knew, that they're basically saying because they had two different cases that were merged into one, the two plaintiffs, Franchi and Usbaldo Muniz, did not do the statutory claim. Allegheny put forward the statutory claim. They re-reviewed the statutory claim. They decided that it wasn't going to fly because of Dickie Clay, which they get into at about 17 and 18. Basically, Dickie Clay says that, hey, if you have two classes of shares, one's highly dilutive, one's and you merge them together, it does not activate 242B because voting preferences is not a particularly special right of a class. There was no change in the dividend. There was no change in other things. And like he's highlighting there, 80 years of unchallenged precedent, that's Dickie Clay. And that in 1993, they reaffirmed Dickie Clay. Chancellor Allen rejected the statutory challenge, saying, and this is at the bottom of 18, adverse affects the particular legal characteristics of that class of stock. The right to vote is not a particularly special or characteristic of common stock in the capital structure of Office Mart. So the basic argument there is that since the dividend rights were the same, everything else was the same, and they already had that 242B exception in there. There's nothing particularly special about these two classes. So them voting together as opposed to separate classes does not make sense based on precedent.
I'm going to let you talk about the highlighted stuff here too while I light up my cigar.
Two major problems, however, was AMC certificate specifically allowed for the issuance of preferred shares, which is the 250 is the 151 or 150. It's the blank check rule.
Right.
And that the shares with superior voting rights to the common stock were issued in the past. That was the Class B. I think It was Class Bs that were given to Wanda and all that stuff. So the fact that these were issued is not up for debate. They can issue them whenever they want to because they're already there in the charter. So that's the two big points here, that there's no specific beneficial rights that are given to either of these classes other than voting rights. And voting rights are not a specific privilege of any class. Every class either gets them or they don't. The certificate specifically allows for the issuance of these shares, and shares with rights that are superior have been issued in the past than the common. So there's no reason to even bring up 242 because it's just not applicable.
And I said that from day one, that everything that AMC did was legal. Maybe it feels a little slimy, right? How they did an end run to use the preferred to get enough votes, but it was not illegal. And then they talk about the snap FOC, and that was the more recent case, right?
Yeah, that's the one where they had to disclose that some of the plaintiffs were appealing that. But otherwise, yeah, that basically it was ruled by the Delaware Court of Chancery that a relatively similar situation was not in violation of 242B.
Moreover, Izzo ignores all nuance of the facts and arguments in the snap FOX appeal. Yeah, they sent her out to the back with some switches and spanked her bottom.
Well, because she came at them hard and fast, and so they're defending their position as the lead plaintiffs, and she's trying to. What I find funny, and I don't remember where it was in here, they point out that, well, Izzo's trying to set herself up as the lead plaintiff in the hierarchy structure of the plaintiff side of things, but she owns more APE than she does AMC, so that her lawyers had to admit that that's a conflict of interest. Not saying that owning more APE than AMC is a bad thing. It's just a bad thing if you want to say that you should be running this case instead of another shareholder.
There's a lot of pages here where she's trying to calculate the percentage impact of the settlement, and they're walking through her math. Did you want to talk about her math? I don't really care to talk about that.
I really don't care to talk about her math either because it was a whole lot of supposition.
And it was all incorrect, and they tear it apart here.
Like the math I gave was like better than her math because she was assuming that based on no facts whatsoever, a downward trajectory in the share price and everything, which it's going to happen from the arbitrage, but there's no saying where it would go after that. And she doesn't do anything to, set up where she was going with that. So it's pretty meh. On 27, they bring up the fact that, hey, the new law that's coming kind of makes this case all sorts of moot. And so the get for shareholders is much better.
I was curious if anybody was going to bring that up. For those of you that don't know what we're talking about, on August 1st, there's going to be a vote in the Delaware legislature that's going to change Delaware general corporate law, if it passes, to allow companies to do a reverse split without a majority shareholder vote. The very thing that's under, that caused AMC to have to create the APE, the necessity for more than 50% of shareholders to show up. Delaware is about to change that law for every corporation.
Yeah.
And so, they did stick that in here. We don't need to belabor that point, but it is mentioned in here. That did you want to say something about it?
No, I was just getting ready to sprint over to page 29 where they get into all the people giving their other options for settlement proposals and then basically saying, look, the job of the court right now is not to debate what is a better settlement. The only thing that can be debated right now is this settlement. And is this settlement fair given the range of reasonableness? And that it doesn't matter if other people think that other settlements would be better than this one. You got to beat this settlement.
Oh, yeah, here we go. Here we go. Some objectors offered a bunch of proposals that bear little relation to this action and would provide no class recovery. Yep. Okay. Including implementing side businesses. Like, when I saw that, I was like, what the heck?
You mean the things that they're already doing?
The things that we already did, right?
Which the plaintiffs' lawyers even bring up.
Hiring stockholders, I guess, to work for free for technical work. I'm just adding in the for free. It doesn't say that, but
yeah.
And using stockholders for advertisements, I could get behind that instead of Nicole Kidman.
Yeah.
I don't know about hiring stockholders for
the
technical work.
crowdsourced donations. I don't know how that's even a settlement. That sounds like a punishment. Like,
yeah. People ask me all the time, Tony, would you donate to a GoFundMe to pay off the debt?
Absolutely not.
Hell to the no. Like if I'm putting money in a company, I want something for it. I want to get for my give. I want ownership of the company. I'm not a charity for corporations.
Yeah. I will give them my money, but I want a representation of the ownership of the capital that I put my money to. If I buy a printer, I shouldn't, like, if I give Dell my money, I should get my Dell printer.
Yep. Selling NFTs. I mean, that. I don't know why they haven't pursued that. It seems like a reasonable, but are they going to raise $1 billion from NFTs? I don't know. How much has GameStop raised from NFTs? Was it $1 billion?
I think it started out real well and then it kind of tapered off, but I can't.
I don't think it was $1 billion.
No.
Or 2 or 3. You know, AMC is not looking for chump change. New director appointments, reevaluating the auditor. Like, yeah, people don't like our AMC's
well, here's the thing.
Accounting firm.
Every year, don't they have for vote? Like, I don't know if it's one of those like
it's
recommendation.
It's an advisory vote. Yeah.
Okay,
you can vote on it. You can vote on it, but they're going to do what the fuck they want.
Some companies are a little more lenient on that one, but yeah.
Several objectors contend that the plaintiffs, Allegheny, should have used different or additional claims, like common law fraud.
Yeah, I don't know how they would have gotten that one. Former objectors do not identify any misrepresentations or omissions to explain how class-wide reliance could be proven without the benefit of presumption, like under federal securities law, or point to additional damages sounding in fraud. I assume this is having to deal with the disclosures for APE, but all the disclosures were there. Now, is it like not nice where they didn't make it obvious? Maybe, sure, yeah, but
you're exactly right. Them. Like I've heard people say that, like the whole APE, it was fraud. Unfortunately,
they disclosed everything. You just
it was legal. Everything was filed. SEC, Secretary of State of Delaware, attorneys from many companies looked at it. Citigroup or Citibank, AMC, the board.
Yep.
It was definitely legal. People complained about the reverse stock split, losing 90% of their shares. 90%.
Oh gosh, when I saw that, I'm like, oh no, I'm having.
I had to read it.
Flashbacks.
I had to read it 3 times. It says losing 90% of their value. Yeah, I mean, we've explained that till we're blue in the face. You're not losing anything.
I can't explain how
reverse splits are neutral to shareholder value until they start trading, right? That's but the court is not going to make a judgment on what happens after it starts trading. The court is going to look at, is a reverse split illegal? No, it's not.
More importantly, no objector identifies any legal or equitable challenge to the reverse split. Challenges to the May 14th vote. I assume that's stuff
people said the vote was suppressed, and they go on in this to say, look, the turnout in this vote was from retail side, from AMC Common, as high as any of the previous years. And that is true. In fact, it was higher on 2023 than it was in 2021 or 2022.
Oh.
So the vote was not suppressed.
Yeah, in fact, you had more people show out than
right.
normally do. which is
theories about manipulation in the stock market. Specifically, people are concerned about synthetics. All of us are. Yep. As the theory goes, well, we already know what the theory is. We've been talking it for 2 years. Many believe it includes Wall Street and the government. Regardless of their truth, these theories are outside the scope of the court's assessment of the settlement. And that's really what I've been focusing on. Not that I don't believe in synthetics. Not that I don't think anybody should be upset about them. Of course, we're all upset. But it's not within the scope of this court or this lawsuit. Unfortunately, you're going to have to file a different lawsuit to talk about that stuff.
That's the big point that Chance has always made. That's like the Delaware Court of Chancery is a court of limited case law, limited civil law, corporate law. And you can't bring these things that have nothing to do with what they can rule on.
Many objectors want the court to order a share count. All right. I saw someone post this and he stopped right here. What? It should not do so. How dare they? Why would they not want to do a share count? They, people always clip and don't show you what they don't want you to see. Have you noticed that, Corax?
Yeah. Yep.
While certain objectors claim that the actual share count is unknown or unknowable, the actual number, drum roll please, is 519 precisely. 519,192,390. Guys, I've said this umpteen million times, and I know the clickbaiters don't like it, but AMC provides the share count. They issue the shares. They know the count. That is the count. That will always and ever only be the count. Someone go, please tell Lou to shut the F up, because he taught a bunch of people a mind fuck that they can't recover from. That is the damn share count. Now, I know what you want. I'd like to see it too. A DTCC share count, right? AMC does not know the DTCC share count. The Court of Chancery has no ability to go ask the DTCC for their share count.
The DTCC is an SRO, immune from...
And once you go sue them, they're going to tell you can't sue us. Sorry.
And also, I have a fairly good idea of what the DTCC would say, even if they were compelled. That number exactly right there, because all that shorting creates is a liability. I owe you this share. It's an IOU slip. It does not create a new share. Like, you can use the term synthetic or whatever, but it doesn't create a new share. It creates an obligation. Like, if I borrowed Tony's shares, the agreement between me and Tony is that at a future date, I own Tony his shares back. So the share count remains the same.
And when I talk about each and every one of you evolving as a trader, I want you to evolve to be able to read past the clickbait and the retail bullshit that is put out there on every ticker, guys. I see this on many tickers. We need a share count. We need a share recall. It's all bullshit, because a company can't do a share recall, and the share count is published by the company. That's it. There's no other answer except you're being lied to by people repeating something they heard from somebody who doesn't know what they were talking about.
You.
So let's all collectively get better and resist this letting people screw with your minds, telling you stuff that they don't understand. If you want to go sue the DTCC and get a share count, I will be right there with you. And I'll say that's a legitimate request. But you also got to recognize suing them is probably going to get dismissed with prejudice, because they're SRO.
And I can tell you that for a fact, because that's what all the MMTLP people are figuring out.
Well, and I can tell you that for a second fact, because as we've mentioned here, an attorney who's everybody knows his name, tried the very thing, suing the DTCC in 2008, and had his case dismissed.
Yes. For
naked shorts, share lending, all that stuff. So it's unfortunate, but I'm not going to hide the truth from you and keep on putting out 20 tweets a day saying, why can't we get a share count? The truth is the truth. The facts are the facts.
Yeah. And in fact, in a video that I did on when Al from Boston filed his motion with the court about bringing the DTCC in, I cited a case where it specifically said they could very well have done something that might be fraudulent. And you know what? They're still immune to your lawsuit. The only people that can regulate them is the SEC.
Where's involved?
Yeah.
Really? This is going to be a long ass fight because they set the system up to answer to fucking nobody. The only people they answer to is Congress. And I don't even know what chance we have there. Please, God, give us term limits one day in our life.
Hey, look, I'm all about that. Amen, brother. Like, regardless of what if we agree or disagree on the issue, like if we can get term limits for state and for the president, I don't see why we can't get term limits for the rest of these yahoos. I should not be able to vote myself into eternity serving in Congress.
Now, I found this interesting because this is Allegheny saying this, that the existence of synthetics was proven false when APE was distributed. Now, I would have expected AMC to make that argument. Did this rock you a little bit?
Nope, not in the slightest. I know that it surprised a lot of people, but like I had just said, that it's an obligation between, if I borrow Tony's AMC shares and sell them short, it's just an obligation. And that means that someone else, either they're out on the open market or they're bought by someone else. So those apes still will exist. I just got to figure out how to get them. So like most people who are selling short will get out of the way of that van and close their position. But like, I knew that that's exactly what was going to happen. And that's exactly what plaintiffs were going to say.
The troubling thing with those allegations that were made and the objections is that they provided no evidence or coherent explanation to support their claims. And look, I believe there are synthetic shares. I've listed out many, many, many times over the last 2 years how I believe that they exist and the different formats like FTDs and shares that are legally lent out, market maker naked shorts. There's all sorts of different synthetic shares. But unfortunately, beyond that, all of the billions that people talk about, no one that objected provided any evidence or coherent explanation. Saying you have a belief is not going to be good enough in a court. That was kind of what I was, the point I was trying to hammer home over the last 2 months. Not because I don't agree with you about synthetics, just trying to save you some heartache that you got to have evidence in a court.
The next one's my favorite one. Like, it doesn't even deserve a response, but every time I see it, I kind of have to chuckle. The AMC crypto token.
All right, I'll let you talk about that one. I just skipped over it.
Okay, first of all, if you think that that FTX, the absolute scam of FTX, actually was 1-for-1 securitizing AMC shares through those tokens, I have some oceanfront property in Arizona to sell you. And that's where I'll leave that.
There are a lot of people right now I see that believe in the tokens being used. And look, of all of the things that I have to spend my day on, this is one of the ones that I have not looked into very deeply. Like I looked at Etherscan and saw that the tokens weren't being traded since like 2 years ago.
Really?
I know that FTX is a fraud. I know that if they sold tokens, they probably never backed them up with anything.
Yep.
And I kind of just stopped right there. And if I said, look, if any of y'all find something, let me know.
I didn't know they had even not traded. The second part of your point is what I latch on to. If you think that FTX was not being shystery and all the other shysty stuff they were doing.
Yeah, so I don't have much comment about tokens other than that. It's still an open question in my mind. But when you say FTX, that's probably not the one I'd use.
Tony uses open mind properly. My mind is open to the possibility, but not so open that my brain falls out.
Yeah, I'm open to being convinced. I mean, show me the evidence that tokens are actively being used, and you can sway me. I'm not shut off to having a good discussion about it. But you got to come at me with something. Look, I know people have 2-hour videos going on and on talking about it. I'm not going to watch a 2-hour video. I need a 5-minute summary.
Mm-hmm.
If you can't get your point across in about 5 minutes, then you already lost me. The views of the party involve pro and con do not support the denial of the settlement. Yeah.
Izzo brings up that the settlement is.
We're still talking about Izzo. Can we move on already?
Well, they're going to make a big thing about Izzo because they're challenging for leadership. So
okay.
they gotta play slappy hands with the Izzo objection through most.
Moreover, a large percentage of objectors are not really objecting to the fairness of the settlement, but rather to various other issues that are irrelevant to this action or otherwise unactionable. I mean, same shit we've been talking about for 2 months here.
Yep.
And
that's why I've started taking your advice and stopped going over every little nitpicky thing, because at the end of the day, that's what it comes down to. Ain't none of this stuff got anything to do with what's going on.
And I agree with a lot of the stuff that people are putting in their letters. My only whole point was, as trying to analyze this case, those are irrelevant to this case. I'm just going to keep on saying that for the people that are just dropping in.
This D point is the one I'm most disappointed about, is the not necessarily the scope of the release, because they're going to talk about the release obligation, but just the fact that people couldn't even reach the part of explaining how the settlements give and get, that they couldn't even come up with a rational way to even say that the settlement isn't worth the value that they're projecting it is. It just, every time it comes back to that, just like, I'm glad I'm going to get paid because they couldn't figure it out, but it just seems like a big missed opportunity.
Talking about Izzo, about future claims, I don't really care about that.
Yeah, no. No objector advances a valued argument against class certification on non-opt-out rule 23B1 or B2 basis.
I don't want to talk about non-opt-out. The judge is going to decide about that.
Izzo cannot lead the case. B, according to Izzo's objection, intends to intervene and seek leadership of the class. Of course, in any event, Izzo owns more apes than common shares and is therefore inadequate due to her antagonistic interest with the class.
Yeah, this is talking about if it should be a class act, should there be an opt-out, right?
Well, this part
class certification
is who? Yeah, class certification. Who should lead the class?
I'll let the judge decide that.
Yep,
it's not worth.
Motion. To
Izzo cannot lead the. Izzo cannot lead the class. Is that an extra is?
It might be.
Fuzzy Wuzzy can.
Oopsies. Someone forgot to proofread. Moving to lift the status quo order does not impugn plaintiff's counsel's adequacy. That was an interesting one, and they go in to explain why they did that, that there's certain cases, I believe they cite in R.E. Wrigley Jr. Company shareholder litigation, where basically said that because it was very time sensitive in nature, they were able to get the court to agree to allow some of the terms of the settlement to be done in advance of approval of the settlement while they were still hashing it out. But they go on to say that basically we understand the court's decision and we in the end abided by it. So even though that we thought that this thing worked and it didn't, does not impugn that we later followed the court's instructions.
Lifting the status quo. The class is properly certified. I don't care about opt-out.
Notice here comports with due process. That had been a big argument by Affolter and them about due process, and they go
What
over
page are you looking at?
52.
52?
Yeah.
Hang on. Let me scroll
Yeah,
down.
no problem. If you got stuff in between there.
All right. What do you want to read?
Just basically going over that they mentioned that the whole due process for people with the postcards was kept up in publication notice. I just brought it up briefly. You can do what you would, because I know that they had made a big shuffle about people's due process rights.
Yeah, if y'all are just joining in, we went over the postcard affidavit at the very beginning of this video. So if you want to know what was said and submitted to the court today about postcards, go back to the beginning of the video when we're done.
But they basically said the fact that people feel that their due process rights were not honored, they were honored, and it's not a reason for the settlement to be objected in any way, shape, or form. I don't know if you really want to go over this that's coming up next on 54, but they basically go over the different standards for how the fees are determined and everything like that.
Oh man, I skipped over this part because I wish that, they would get nothing. Honestly, it's a big colossal waste of time. It was all a money grab. This lawsuit should have never been paid in the first place. And the fact that these attorneys are getting so much money just makes me sick to my stomach.
So they go over the Sugarland factors and all that stuff. Basically, what's the benefit achieved? What was the difficulty of the litigation? And what was the time and effort spent on the litigation? Those are the three Sugarland factors.
They're justifying their fee here, basically, on these pages.
Yep. And again, this is where the objectors fell down. Like I said,
yeah, go ahead. Go ahead and finish your sentence, and I'm gonna add on to it.
They totally fell down because, as I explained in the video that I have on my page, it's like the second video. I think it's a few good objectors. I did a joking reference to a few good men for the video, but the part two of that was basically, look, the entire value of the settlement is based on the spread between the conversion price when these two converge into one. So as we get closer to conversion, the two prices are going to compress closer and closer together as people think that the arbitrage is more than likely to close when the two securities come together, which means the value to shareholders gets smaller and smaller as we get closer to that time period, which means the value to shareholders gets smaller, and therefore the value that these people should be getting should shrink too. And in fact, I suggested that the court shouldn't rule on the fees to the attorneys until after the ruling to determine what the actual value to shareholders is on the close date of the transaction. And then you pay the lawyers, because it could be that the arbitrage completely closes and then there's no value to shareholders. So what should these lawyers get in fees when they did nothing?
The add-on I was going to add to your statement is I find it ironic that all of these objectors are just further enriching these attorneys by billing hundreds and hundreds of hours to answer all this shit.
That was brought up in docket ID 356, where they said because of the Sugarland factors, that time and effort are considered part of the fees. The reasons for collecting fees, that every time they send in one of these frivolous statements, and every time that special master or model, because that's also being billed to all the shareholders too, the fees and everything that are being racked up from Amato having to respond to everything, that's all getting billed to the shareholders.
Yeah, every letter in motion you send in is paying these attorneys, these crooks, another $1,000, $2,000, $3,000.
And it was pointed out
minimum.
Yeah. And it was pointed out at the end of that opposition to Affolter's motion that Garfield v. Box that, it may be a secondary or tertiary consideration, but I'm being billed for what these people are doing, and that they should have to be liable for all these costs that they're putting on shareholders by doing these frivolous motions. But that was the entire argument of the respondent there.
We're almost done with this document. Then we'll look really quickly at Amato and Zern. What they filed today, those are very short. So stick with us, and then we'll answer whatever
But
questions.
The Zern one is very important, especially for the people that continue to be belligerent on the docket.
Yeah, so they just wrap up saying we've earned every
penny that we deserve
of that 20 million we're about to get.
Yep.
Mother. All right. We need to go over to the other website.
While you're doing that, I'm going to disappear real quick.
All right. Report and recommendation of special master regarding Jordan Affolter. Let's look at the order denying. Let's see if that's. All right. We'll read this when Corax comes back. This is the one signed by the judge. Yeah. All right. I can take one or two questions while we're waiting on him to come back.
I'm not a big beer person, but I've got a crippling addiction to hard cider.
Oh, nice. I'm not drinking for hopefully a maximum of 2 weeks. I'm halfway through.
Oh boy.
So I've got water tonight. Normally I'd be joining you with a scotch or a bourbon.
Nice.
You come to judge, Headstock Karam says.
No boy.
All right. I pulled up the judge's order.
Honorable Vice Chancellor Zern.
Yeah. Denying Affolter's exceptions.
Most of that first part is background, I believe, the first 2 pages, except for getting out in front and saying, "Hey, I'm disregarding this." I think the real meat starts on page 3.
A hearing on his exceptions is not necessary.
And in case you're not familiar with that Latin word de novo, it means that the judge is taking it up without prompting from any of the moving parties. Basically, Affolter filed his letter and she's like, actually, guys, I got this one.
Special master denied his motion to intervene. He did not take exception. He is a non-party without standing to move this court for relief.
I think we brought this up last time we talked about this. None of them are parties. None of these people who are filing their motions, because their interventions were denied, they are not parties to this. The only parties are the plaintiffs and the defendants. And if you ain't one of those two, you are not a party.
He also has not submitted an objection. Did you know that?
Yes, I did. It was hilarious when that was pointed out. I found it fucking hilarious. There are several of them that did not file objections. There's several of them that filed objections and didn't file proof of ownership.
But he had time to help draft a 67-page form objection, but he couldn't be bothered to file his own.
Yep.
Amazing.
It's hilarious, isn't it? It's great. It's a great joke.
And Judge Zern says he had no difficulty utilizing the information available to him to craft this 67-page document.
She just clobbers him from the word go, and it's hilarious. You can tell that she's getting tired of this, especially with footnote number 20.
Yeah, let's talk about this last sentence right here.
Yep.
I'll let you read that one.
As for prejudice to other shareholders, Mr. Affolter is not an attorney. Representing the interest of other stockholders in this proceeding risks committing the unauthorized practice of law. Cite the footnote 20, and I find footnote 20 hilarious. First of all, I saw that first citation on footnote 20. See Delaware State Bar Association versus Alexander, and I'm like, I've seen that one before. Oh yeah, that's right, because I saw it in DI 356, as you see up there. It's also in that one too. It's footnote number.
Did somebody get in trouble for trying to act as an attorney?
No, it was cited by one of the other pro se litigants against the other pro se litigant.
Oh.
And it's citation number 7 on DI 356 in this same case. And I find it funny that the judge brought it back up. And instead of just using the tiny excerpt that Mr. Tabor used, she's like, no, read the entire ruling. It's very important. And I read it. And it's basically this guy who was LARPing as a family court lawyer, and basically got caught in it. And there was an order by a court from a special master basically telling him, stop it. And he didn't stop it. And so it went to the Supreme Court, and the Supreme Court said, we have final say on all of this, so you will stop it. And by the way, enjoy this penalty from us.
Wow.
And it's because the Supreme Court of Delaware is what gives the power for lawyers to be able to have law. They have to be a lawyer. They have the final say on it. They're the ones that regulate the Bar Association. And basically that whole ruling you really should read it because it's a good read. But it goes over that the practice of law is not just, appearing in court as a lawyer. It's giving people advice and taking money for that advice. It's writing documents for these people, hint, hint, nudge, nudge about the objection suggestions. It's, all of these things that basically these objectors were doing, including trying to represent them in front of a judge in a Delaware court.
I just wonder about that. Like if you are filing pro se, Latin pro se means for yourself. When you're creating a 67-page document for other people, you are, in essence, I would think an argument could be made, acting as an attorney for those people.
And she goes on to be like really nice about it. She just does step by step. The first one is, hey, read this whole thing because you're kind of brushing up against it. Then the next one is, the court does not exercise the inherent authority to regulate the practice of law for the purpose of protecting the financial incentives of the lawyer. Our role is to ensure that the public will enjoy the representation of individuals who have been found to possess the necessary skills and training to represent others.
Oh, Al. Oh, Jordan. I hope they don't get in trouble.
We'll get to that. That's at the end.
I hope they don't get in trouble for acting as an attorney, coordinating all this shit that's going on for other people. But yeah, she's clearly warning you're risking committing unauthorized practice of law. Yeah. Wasn't there a footnote somewhere, Corax, that said Al has admitted he's not an attorney?
That's at the end. And I said that I was going to cut that, put that in a frame and just put it on the wall. It's right at the end of this whole thing. It's hilarious. But as expected, denied on all the exceptions.
All right. Judge Zern is talking about the publishing of public exhibits. Lead counsel explained the delay, and the court accepts the explanation.
Yep.
Now, that's got to piss some people off. So, denied. Second exception.
Denied. She basically just kind of brushes over it because it's all the same stuff, and just like, I'm done with this.
Yeah, that was quick. Denied.
Leibovitz is just like one paragraph, all the same problems, go away.
And then he threatened, even if you deny all my shit, I'm still going to file some more. And she said,
and the court says there's no guarantee.
She said, you're free to submit anything you want, but there's no guarantee we're going to consider it at this point because we're on a schedule and we're sticking to it.
Yep.
All right. We move on to my friend Ethan. Ethan's has exceptions. Judge Zern asks him to consider this order as he drafts his submission. He's not party
exceptions.
and does not have standing
I forgot about
with
that.
the court.
Ouch. The court for relief.
I didn't even know that.
You are not a party.
Why
you
is
didn't
he
even write an objection?
He sure is vocal for someone that has no standing in the case.
I know, right? A lot of these people are.
Oh, this is the one that I retweeted this morning, though. His concerns about the timing of the postcard are of no legal import. They're not important.
I love
because
that
he clearly received timely notification of these proceedings.
Yep.
Now, make no mistake about it. The postcards were your notification about a lawsuit hearing on June 29th. And if you bothered to bother the court saying you didn't get your postcard, they're going to say, thanks for admitting you knew about the lawsuit.
Yep.
And we wash our hands. I got people really mad trying to say that you were going to get that answer. But when I try and be helpful, if people don't agree, they just, they go into insult mode instead of trying to maybe just consider, what is this fucking cowboy talking about? No, they just want to insult me that I'm some shill or paid off person. I'm trying to be as impartial as I can and be helpful. But I get it. You don't agree. If your first response is to get angry, then just don't look at my shit, because I'm not talking to you. I'm trying to help people that actually want to listen to reason and at least think about things. And yeah, the judge just smacked him. All right, we move on to Mr. Matthew from Boston.
But no, using his own words against him.
Well, this is pretty short.
Yeah, it's even shorter than the one paragraph he gave Ethan.
Oh, what was he doing? Was he clapping Affolter from the back?
Well, what he was doing is that while all of these exceptions to the special master's report was going on, of course, Al's ego got in the way and everyone was ignoring his frivolous motions. And so his next objective was to write letters in support of the exceptions. But you're not the movement. You can't do that. So of course, Vice Chancellor Zern's like, you know what? You did these letters in support. I mean, I guess if you want a gold star, here's a gold star, but I don't care.
She ends by saying Mr. Matthew can't speak for someone else, right?
Because, and footnote number 28, Mr. Matthew has acknowledged he is not a lawyer, and then uses his own citation cites his own motion against him. Additionally, Mr. Matthew has some legal experience being an L1 sick in law school.
Not anymore, because he quit law school.
I don't think he was ever to begin with, but I like that she just kind of takes his own words and slaps him across the face with it.
Got to watch what you say. That's why you want to go in this with a real attorney and not be writing your own letters. All right. What was the other one that we wanted to look at?
I think there was.
I want to see the one where it was the special master said, just deny anything else that comes our way.
I heard you mention that, but I haven't seen that yet. So yes, please. That would make my day.
I think it was this one. From Corinne Elise Amato, June 6th. I recommend that the court deny Affolter's motion for equal protection under the law regarding access to confidential information and discovery. Background, we already know the background.
Mm-hmm.
Affolter has not sought access to the discovery record. I find
that's the big one. They keep complaining about it, but they have never, ever, ever, ever
did not submit an objection.
Yep.
Filing motions. He contends that the parties have traded on inside information. Therefore, the court should impose broad trading restrictions on anyone with any access. I think, most of them are already prevented from trading.
Something SEC rules.
Yeah. He wondered if he could still trade if he put his stock in a blind trust.
And that'll be a big negative there, Charlie.
So Amato says, I recommend to deny. He's not a party, first of all.
They keep not listening to that one.
I know.
There's like, I've only heard one of the pro se litigants that seems to get the message on that one, but they keep missing that, reading past it.
And as to the allegations of other parties doing insider trading, he provided no evidence.
To satisfy Court of Chancery Rule 23.1. Confidentiality order. And there is a comprehensive array of federal statutes in place addressing insider trading and subjecting corporate insiders in various forms of punishment if they violate federal law.
Yeah, I mean, some of these guys, Corax, they just think people are violating law left and right. You know, they don't care about that law. Adam Aaron's probably even shorting his own company. He's probably trading right now.
Yes, and the Twin Towers were brought down by thermite. Yes.
Oh, no, let's not even go there. All right, blind trust. They already smacked that down. I want to get to the part where she said, just ban them all.
Cohort confirm the respondents. Conclusion.
Oh, this is not it.
Huh.
Let me find it. I posted it in my Discord this morning.
Because I want to see it, because there's been a lot of silly, like these motions that they've been told time and time again by the court. You were not a party. You did not object to your motion for intervention being struck down. Your time for speaking has up. We've got the Jeopardy wrap it up music playing in the background. You're done.
I think it might have been. Did she file one about Matthew also?
Maybe. I can look at that. See if I can find it.
Yeah, here it is. The last one.
Oh, Matthew's motion for issuance of stock certificate. Oh man, is this the one where she points out that Matthew is like that Al has filed like what 13 motions with the court?
I think so,
including over 300 pages of memorandums.
800 pages.
800 pages of memorandums that have.
That's probably the same thing he submitted to the FBI.
I have no doubt. Which have nothing to do with the case at all, untethered by any motion to any motion. These filings
many of these filings raise issues that are far beyond the claims and defenses in this action and improperly seek discovery and other relief from non-parties.
Yeah, if you are not a party, if you are a party to the case, you can't seek things. Well, if you're a non-party to the case, you can't even do anything to begin with. But you like if they're not a party to the case, then like the court can't do anything about them.
He's been asking about share count at the DTCC. We've talked about this already.
All sorts of nonsense.
Oh, I'm going to let you talk about this because you already, I know this is one of your favorite hot buttons. When he was looking at Allegheny's reports and trying to guess their holdings based on a top 10 report. Even when I was watching that, I was like wanting to bang my head into the table.
I saw the documents. I'm like, seriously? I was looking at the exhibits. I'm like, what?
Special Master Motto Corax broke down here exactly what you said, as far as what she thought about trying to do that.
Oh, in the footnote or up here
in the document.
In his motion for Matthew claims there are significant debt discrepancies in Allegheny's quarterly investments. He believes this calls into question Allegheny's ownership of both APE and AMC shares. Matthew makes other vague, unsubstantiated Mr. Matthews' extended memoranda includes similarly vague and unverified allegations regarding Alleghany's quarterly reports and stock holdings that are also factually unreliable. Matthew, however, appears to have focused on lists that identify Alleghany's top 10 weighted stocks and top 10 performing stocks by quarter and bottom 10 performing stocks by quarter. The AMC stock is not identified because in these charts, in every quarterly report, but there is nothing remarkable about this since the charts are not, as is evident from their titles, intended to be an extensive list of the Alleghany stock holdings. No shit.
I mean,
you don't say.
I'm not very smart, but I could read the title of the table, and it was
yeah,
pretty.
I know.
I figured out in about 5 seconds that was not a list of all of their holdings.
I was at
top
work
10 is top
skimming,
10.
and I was like, are you fucking serious? Yeah, I bet that burns his ass cheeks that he got told he was an idiot live in front of everybody.
He was so sure he had the smoking gun. He probably did a 2-hour live. Breaking news. Come in here, guys. Get in here. Get in here. Join the Discord. Support Al. Access to Al. $50.
Spend $10 for me to give you bullshit information like this.
$50 for bullshit of the day. Join right now. Here you. Come on. Come on. Come on. All right. Let's move on.
Yes, Anna. We are soulmates because we have zero time for bullshit. Zero.
Matthew does not even attempt to make the requisite showing for additional discovery. Could have access, but chose not to access the existing discovery record. Again, look, if you're that serious, fucking access a discovery.
Put up or shut up.
Exactly. It's all smoke and mirrors. It's all clickbait bullshit. And yeah, I'm just going to stop right there. Possible misuse of funds, potential conflicts do not rise to the level of prima facie showing a bad faith and conflicting interests required to obtain post-settlement agreement merits discovery. Damn it, I still can't find the part. Where is the document that said deny them all? Maybe it was in the one that we looked at before.
Maybe.
Anyways, let's take some questions. I'll see if I can find it. I'm looking through what I posted in the Discord.
I'll keep an eye for questions.
Go ahead and grab some questions if there's any good ones.
Yeah. Does the settlement pay us? Yes and no. It's a payment in shares. So it's basically like a stock split, a limited stock split for only AMC common shareholders. It's nothing special. I'm sure that would make some people very angry that I said that, but I've been pretty open about that. The settlement is, it happened. Yeah, the 7.5 is still on the table. That's what this entire process is about, deciding if that is a fair settlement within Gus. Says that's where I disagree with you, Tony. And the reverse split will affect shareholders with averages over $20 or over. Some that brought over 70 would have same price. They'd be trapped forever. Yeah, that is a choice. I don't deny that. It sucks.
Because their basis is going to be stepped up 10x. Yeah, I mean it's a reverse split. Nobody's arguing that.
Yeah, it sucks, but and I don't deny it doesn't hurt people who bought at those highs, but that's why I didn't buy there.
I said something last night that made a lot of people really angry, but I'm going to say it again because I fucking mean it, and I want you guys to wake up. #evolve. If you are investing in money-losing companies, boy, that hurt a lot of feelings too. You're invested in a company that is losing money. Should not be inflammatory. You should have the ability to self-reflect and say, yes, I know I did. Right? Don't get mad at me for saying that. I'm just speaking the truth. When you're investing in companies that are losing money, if you hold them long enough and they don't make money, there's 2 or 3 things that are going to happen: a reverse split, dilution, or bankruptcy. until what? The fundamentals improve. This is a universal law. No company can lose money to infinity except GTII. Why? Do you know why GTII can lose money to infinity?
Because they have shareholders that are willing to eat the bullet.
No, because the CEO is writing personal checks to fund the company.
Oh, well, that makes everything work, I guess.
Yeah, and nobody's taking a paycheck. But yeah, that's kind of a unique case.
I mean, that helps. I've never really followed GTII except to know that it's kind of a steaming pile of crap.
It's another pump and dump. It's another retail scam. Now that you can have FOMO runs in those, but there's nothing redeeming about it.
And not to say that, taking on a certain level of risk that has a potential reward isn't something that you can do, but you also have to understand what those risks are and own them.
And that's kind of where I was last night, right? We want a portfolio of profitable companies. Mm-hmm. And if we choose to allocate a portion of our portfolio to speculative plays, money losing companies that could short squeeze or that are having a FOMO run up today or tomorrow.
Companies that could be good when they get out of bankruptcy.
Right. Bankruptcy plays sometimes. Look, I have no problem with that. But I want you guys to have the ability to admit to yourself that you bought a company that's losing money and not let that make you mad at me for saying it. It is the truth. And once you can accept that, I want you to know going forward that if you hold those companies long enough, I've got a list 50 long that I could tell you. There's only, until they improve the fundamentals, there's 3 outcomes. Reverse split, dilution. I guess I could add in raised debt, but most of them are too far gone to raise debt, or bankruptcy. That's how they all end up if they don't fix the fundamentals. So that is the evolve. Like, I want you to internalize that. Before you buy something that is losing money, how do I know it's losing money, Tony? Read the financials. Another core tenet on this channel. I want you guys to get better. At least if you're holding it more than 3-4 days, if you're going to end up holding it a month, 6 months, you better know what you're holding. Are they losing money or making money?
Read the financials and understand how these companies game the financials to make them look prettier. That's why one of the ones that the first books I read was called Financial Shenanigans, 4th edition, where they basically go all the different ways that companies do sleight of hand tricks with the balance sheet, cash flow statements, income statements to make them look pretty one quarter, and the next quarter, like GameStop, you get surprised with a hardcore loss and everyone wonders what the heck happened, and the CEO is getting fired.
Folks are wondering, well, why did Tony evolve in this play? Because we're not in 2021 anymore. Mm-hmm. We're not in a robust economy. Money's not flowing from the government into your checking account every week, like rain.
Federal funds.
Interest rates are up. Yep. Capital is leaving equity markets. It's leaving the stock market. And AMC doesn't have $2 billion in the bank anymore. I mean, let's be honest with the situation. We're in 2023 and we're not on our home field anymore. We're on the visitors field and we're down on the score. We're running out of cash. So if you're wondering why is he talking a little bit different about this play? Because I have the ability to change my tactics and my analysis. I didn't care about the fundamentals in 2023. We had $2 billion in the bank, and we had a lot of people willing to pile money in, and we had a chance to squeeze them again. But things changed, guys, in November of 2021 when the market started sliding. So I had to change my outlook and how I approach this every day. And now we're in the 4th quarter, and we're going to get some extra, we're going to get some extra time on the clock, or we're going to lose the game depending on what happens with this lawsuit. That's literally where we're at.
And the good news is, I think the settlement, like 99.9% sure the settlement gets approved. So.
I am too. So the risk of bankruptcy is low if the settlement is approved. If it's not, I'm going to keep on saying that nasty B word.
Yep.
All right. Who wants to ask me a tough question
about Tesla? That's out of my leagues. I don't deal with Tesla.
Six Son, no, I have not been playing Tesla. Last time I bought it was when it went to 100, and I sold it on the run up, and I have not bought back in because I keep on being greedy and hoping that something was going to happen where it would come back down. Maybe I need to go in there and start trading it again. I was just, this fucking shit with AMC has been sucking up too much of my time, to be honest.
It's kind of where I'm at.
I'll be very happy when we get to the end of June. I don't got to talk about this damn lawsuit. And I'd love not to talk about it at all, except for the people that are relentlessly pushing misinformation. I almost feel an obligation to be the one voice besides Corax that is trying to provide you guys some non-emotional, reason, logic-based analysis of what's in these documents and the just straight up bullshit that these people are talking about with their objections and their letters.
I'm also the same way, and I've also got a lot of my capital tied up in this arbitrage play. So until it concludes, I'm kind of...
Well, I'm a shareholder too. I have a vested interest, but why am I posting so much about the lawsuit? Because there's so much bullshit. And it doesn't mean I disagree with them on certain things like synthetics and dark pools. I agree with all of that. But this lawsuit is not the place for it. That is the whole fucking point. You're being railroaded around emotionally by people who don't know what they're doing. And I get it. They're emotional. They're upset. And they're not in charge. No, none of us are in charge of what's going to happen. The judge is in charge. And the plaintiff and defendant have agreed on a settlement. No valid complaint, no valid objections to the settlement were lodged that I know of.
John, do you think AMC, that ape will run up? And I'm like this, it's really hard to tell because we know conversions is going to happen. And once the ruling comes out, they're going to rapidly compress into a direction. I don't know if ape's going to run up high or AMC is going to come down low. I would think ape would go up high. That's what would logically make sense because that's your last chance to get ape cheap before the conversion. So I would think ape would run up to AMC, not the other way around. What do you think, Tony?
I'm not making any firm predictions on what's going to happen because we got legal uncertainty. We got Q2 earnings, which if they're positive could be a great catalyst. But at the same time, even if Q2 earnings are a great catalyst, who's going to be buying? Is it going to be retail? Is it going to be institutions? What are institutions thinking right now about the lawsuit? I don't really know, but I'm thinking they're probably thinking like I am that it's going to be settled. And so do they want to buy AMC at $6, $7, $8? Or do they want to take the opposite side of that trade? Because they know that right after that is going to be the reverse split and conversion, which is going to do some funky shit to the price of AMC and ape.
And the spread is still wide as heck. It's $1.10.
And the other thing about those things that I just talked about is I don't know the timing. Like, when is the judge going to give her written opinion compared to when we get the Q2 results? So I'm staying out of the recommending what anybody do at this point. The time to buy ape was when it was 65 cents to $1. Right now, you're on your own, guys. There's still some opportunity. We see it, but I can't tell you what's going to happen in the next 60 days.
Can you explain the difference between Cinemark and AMC?
Yeah, that's pretty simple, Tom. On any stocks, you cannot look at the price. We were looking at AutoZone yesterday. at over $2,000. Why is it over $2,000? But the PE ratio is 17. When you're looking at Cinemark, I want you to go look at the outstanding shares. It's in the neighborhood of 150 million, give or take.
Yeah.
And AMC's got 1.5 billion. So price is relative to the number of shares. It's price per share, right?
Yeah.
What's going to happen when we collapse our outstanding shares with a reverse split? We're going to drop down to about the same outstanding as Cinemark, 150 million, and our price is going to go to 26, 28, 30.
Puts it about the same neighborhood too.
And it'll be higher than Cinemark.
Yeah.
So that is my evidence to you that price is irrelevant. I want you guys to stop looking at price and comparing stocks. Just get that out of your head. That is a beginner mistake. You have to also look at the float. And if they're profitable companies, I want you to also look at the PE ratio, but we can't do that with AMC. So
I would even argue, look at the EV to E ratio, the enterprise valued earnings.
There's a myriad of ways to compare companies. I mean, I could do a whole video telling you all the different ways, the ratios and comparisons that we do, but we're still dealing with a lot of beginning traders, and that's more advanced. I mean, we got to get this basic point right here home to everybody. Don't look at the price. It's a misleading indicator. All right, what else y'all got? Steven says retail doesn't understand market cap. I know, brother.
Oh boy, Gus. Okay, Tony and Corax, last update on scale of 1 to 10. I think we already answered that. Be converted. Like I would put 50. Like I'd put 50K on that. I mean, I already have. Let me do the math on that. I think I have like 5K on it. That's how confident I am. I'll tell you right now, I got 5K on that trade.
I've said over and over from day one, Gus, and I will reiterate my opinion, my belief, not advice, that this lawsuit would go in AMC's favor. Now we have a settlement on the table, so I'm going to amend that to say that I believe the settlement will be approved. Every time I say that, though, even to the people in my Discord or on Discord calls, I always say, but you cannot rule out the potential that the judge could do something squirrely.
And even
so there's no guarantees on anything.
And even Chancery Daily, I'd have to find the video. I know that CSI, and you pointed to it, where she was even mentioning, I can't remember what the guy's channel was for the life of me, but she'd mentioned that, she's thrown out settlements before, cash settlements. So it's a possibility. I don't think it's a likely possibility given the situation, but
considering the size and scope of this settlement relative to other ones that were the same type of case, probably not likely she's going to throw it out. But you never know. Look, I'm saying 99%, so you guys can come laugh at me. I'm putting myself on the line. I don't like to be wrong. You have full rights to come laugh at me in the comments or whatever if I'm wrong, but that's my belief. That is my honest belief. In the interest of time tonight, and just stay on topic, we're not going to do other tickers tonight. We did that for a long time last night. And I'm sure Corax doesn't want to sit here all night. And
well, especially most of these tickers I have never even heard of before.
Yeah, I just had them I had them throwing them out to me last night, and I was giving them quick, either a chart reading or a quick look at the 10 Qs. We'll do that again soon. Corax, I used to sit there and do that all day on my live streams.
I can't. I'm sure it's fun to do. I just the way I'm programmed, I couldn't do like just on the spot stuff like that, because it's like, okay, I want to go through the company, I want to look at its financials, I want to look at like I just feel like I was being shitty if I just like on the spot, I like this stock, like I'm Jim Cramer or something.
Anya, what's up? Anya says, can you explain how the conversion will happen? Do you have it memorized?
The way
Do you want me to say it, Corax?
you go ahead. That's fine.
So I don't know exactly, like once the judge issues the written opinion, if it is approving everything as we know, I don't know exactly how many days, like boom, 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 is it going to take for AMC to submit the documentation and for the Wall Street to churn it through the system. You know, they got to process it all. But let's put number of days aside for a second. But the methodology of the way it's going to happen, as I understand it by reading all the documents, is AMC will reverse 1 for 10 and collapse. They'll take a snapshot and find out who is the holder of record, you know, all of us. And they will then know who to give the settlement to. Then APE will need to come over, right? The reverse split happened on AMC already. APE needs to come over and convert, but AMC already reversed. So the preferreds can't reverse split. What they're going to do is they're going to modify the conversion rate to 1/10 so that is equal to the new reverse split AMC, and you have a 1-for-1 conversion still. Hopefully that makes sense, or you're married to a mathematician. Corax, did that make sense to you?
Yeah, and that's more or less the way I've understood it. And you'll know whatever that day is, because they'll immediately just be like, halt trading for corporate action. They'll do it, and then it's done, and it goes back to trading.
All right, last chance for questions. 10:30 here. We've been going 2 hours. Yep. I was trying to keep this as short as we can. It was a lot to go through.
Yeah.
Thank you guys for hanging out. I'm watching here for any other AMC or court case related questions. Thank you for listening. Again, I just want to say I'm not for or against anybody. I'm trying to do my best in an impartial way to explain to you what's happening in the court case with the filings. Yes, I voted for the reverse split because I'm looking at the financial statements. That's it. I don't want the company to run out of cash, because if they do, there is a very grave risk of bankruptcy. That was covered on early on in the plaintiff's documents. Allegheny has said it. AMC said it. Even the special master has said it, if I'm not mistaken. Don't quote me on that last one. But that's why I voted yes. I don't care about the reverse split. I could give two shits about a reverse split. But having access to capital is what I'm worried about. If AMC were to have no access to capital, I assure you, I will be out of this play. The day that I know that they have no access to money, I'm out. I'm not going to watch it go to pennies like Bed Bath & Beyond. So that's why I voted the way I did. Now we got a lawsuit. Hey, all I'm doing is trying to, the best logical way I can, without clickbaiting you or misleading you, is explain to you what the documents say and why everybody who's objecting is throwing a bunch of mud up against the wall that has nothing to do with this case. And you're seeing in these replies from both AMC and Allegheny that they both are pretty much saying exactly that. Brave says Bed Bath & Beyond got shorted to death. Well, I mean, that might be the case, but they were a financial disaster, so they deserved it.
What, $250,000, $300 million?
I mean, look, why do companies get shorted to death? Because they're a train wreck.
Financials are bad.
If you can't admit to yourself that the financials were a dumpster fire from hell, then you don't need to be trading. Of course it got shorted to death. Tony two shits Denaro. Juicy. Corax, I want to thank you for your time, Anya, and the other mods that were here tonight.
Always
I appreciate your time. Again, guys, you don't have to agree with what I say. I get it. It's not popular. You're always welcome to comment and ask questions. Just be polite. If you're not, I have no problem blocking, booting, hiding. My channel's not going to be for conspiracy theorists. My hope by the end of June is to have every single one of them blocked, because I want people that want to learn, evolve, make good decisions, look for profitable companies, and for short squeeze plays and day trades, momentum trades. Learn how to get a good entry, recognize a good exit, and have, make money. And if you don't, if it doesn't go your way, have an exit and get the F out. So what we talk about in our Discord I would say every day, but we don't always have a play of the day, but it's a frequent topic. And that is my methodology, and that's what I'm teaching. Get in early, get out early, have an exit if it doesn't work out your way. Wall Street is rigged against you. There's dark pools. There's corrupt government officials.
There's people who this is their day job.
There's people with equipment and technology and intelligence far above ours that can trade lightning times faster than we can. Recognize who you're playing against. Take your money if you made some and get out. I support the fight for transparency and improving things for retail, but in my mind, this is a multi-year battle. And our best chance is going to be addressing it with Congress.
Yeah.
So thank you, one and all. I love you. Corax, thanks for your time. Thanks for being a voice of sanity in this sea of insanity that we got to deal with.
That's what I'm here to do. Just like you, I hope that I'm helping people learn things through the process of this, maybe getting them to look at things that they wouldn't normally look at as they make their random walk down Wall Street.
Have a good night, guys. We will see you on the next one. And for everybody that is a member of the channel, I will see you in the Discord.
Let's go. Yeah. I'm like an addict, do I gotta have it. I ain't even playing, got a really bad habit. If it moves, gotta grab it, fuse like a magnet. Lose, won't have it till I'm doomed in a casket. I ain't playing, got a weird mind. If you work 8 hours, I'ma work 9. If the shit tastes sour, you should taste mine. I'ma stay in power for a long time. Get up, nah, I ain't a quitter. Toss me the ball, I'm a really big hitter. Big picture, I'm a straight killer. Rising the song to the highest bidder. Got juice, got gas, I'ma move fast. New shoes, new tracks, like who's that? I'm new, come back better than last. Yeah, it's an